I can't claim to be an expert in stress. I do my best to avoid it. But it's an issue that's got a growing presence in litigation and particularly in the field of WorkCover. Stress claims are difficult to run. They're difficult for the plaintiff, for the defendant, for the judge, and eventually for the jury. In a straightforward WorkCover claim, the plaintiff will have suffered a frank injury in a specific incident. If that's not happened, it may be a course of employment type injury where a cumulative effect, for example, of a heavy lifting, has occasioned a frank injury. But with stress, we deal with personalities and almost always difficult ones. We all know that workplaces can be a source of tension, and most people accommodate this when it occurs and move on. But there are occasions when a person has a particularly vulnerable personality, or if not, is subjected to unusually severe forms of stress, and as a result suffers from injury. Such cases almost always involve a scrutiny of workplace relations at a micro level. Typically these days, it would also involve an exhaustive examination of relationships between people, including emails, telephone notes, memos, complaints, etc., and discussions between protagonists, perhaps fellow workers, to establish whether a pattern of behaviour is such that the worker has suffered from injury which was reasonably foreseeable and was caused by the negligence of the employer, usually via a fellow worker. I've been unfortunate enough to have run a number of these cases, and by the time they get to court, the plaintiff is always absolutely convinced that there's a conspiracy against him or her, and the defendant is indignant that a person to whom every accommodation was made has had the temerity to sue. However, we are fortunate to have two speakers here who are both experienced in this area and excellent communicators. The first speaker is Caroline Mills, who's come to the bar from Lana and Rogers, where she worked in the personal injuries and WorkCover litigation group. She read with an experienced common lawyer, Andrew Clements, who many of you will know, and Caroline practices in all areas of common law, personal injury, professional negligence and insurance. So relax, unstress and listen to Caroline's paper. Thank you.
Of course, we hear it all the time, and we talk a lot about stress matters and increasingly talk about them as they make up a greater and greater proportion of the work of practitioners who are dealing every day with the Accident Compensation Act. And of course, they bring with them their own complexities, their own difficulties of law, and also major factual and logistical and evidentiary challenges for practitioners. And what I want to do today is to just look at a couple of the pivotal cases over the last few years, including a couple of quite recent cases where common law stress matters have been dealt with by courts. I want to start by looking at the pivotal case of Koehler, which many of you will be familiar with, of course, and then to look at several more recent cases, particularly the two last cases there, Lana and Brown, which are both decisions from earlier this year. And rather than do too much of a very detailed dissection of the development of the principles of law in the area, I want to discuss the principles, but then have a bit of a look at the more recent cases and just consider some of those practical challenges that the parties have faced in preparing them, and how things have been presented at trial and how that's factored into the court's reasoning. So before we get into Koehler, of course, important to remember in all our matters, this of course isn't just stress claims, it's always in the back of our mind that this statement from Suterco of the non-delegable duty of care that the employer owes being a non-delegable duty to its employees to take reasonable care to avoid exposing them to unnecessary risks of injury. Koehler remains the pivotal statement of law in relation to the employer's duty where stress matters are concerned and where stressful work environments are involved. The plaintiff in this case was a highly regarded sales representative who'd been engaged for a period of full-time work with the employer and had then been retrenched but re-engaged in a part-time capacity. She found, once she commenced her part-time role, that her work duties were very onerous, and she had difficulty dealing with the amount of work that she had. She complained to management both orally and in writing on many occasions about her workload and asked to either reduce the number of stores that were within her jurisdiction to visit or to have more days a week of work time in order to deal with the workload. No action was taken by the employer in relation to those complaints, and subsequently the plaintiff developed a psychiatric illness. She brought her claim in negligence and breach of duty against the employer, arguing that requiring her to perform these very onerous duties in a short period of time made it foreseeable that would cause her to suffer psychiatric injury. And of course, the plaintiff didn't succeed in Koehler, and the High Court made some really interesting comments that inform how we run these matters today. In particular, the Court emphasised the importance of the employment contract. The Court noted that the content of the duty of care that an employer owes to an employee must take into account the obligations the parties owe to one another under the contract of employment. And it was held that in general an employer may not be liable for psychiatric injury to an employee if the injury has occurred as a result of the very duties stipulated in the contract which both parties have entered. So it's clearly permissible for an employer and employee to come to an agreement that the employee will perform duties that might be very onerous or stressful or in excess of a regular level of duties or in excess of industry standards. And where the parties have freely engaged in that agreement, the employer will generally not be found to have breached the duty in expecting those very stressful or onerous duties to be performed. The next, in relation to foreseeability in Koehler, before I move on, the other really important aspect, of course, was the idea the High Court expressed that although it's increasingly recognised that stressful work environments or stressful experiences generally can give rise to psychiatric injury, it remains the case that psychiatric injury is less readily foreseeable than a physical injury, particularly to non-medically trained people who might be dealing with a worker in the workplace, and that it's less within the common understanding of your average person who's not a psychiatrist. And the Court emphasised that the employer's duty that is not to be held to the standard of a reasonable psychiatrist with their training in stress matters and psychiatric injuries, but only to the level of a reasonable lay person. And this was important because although the plaintiff had made many complaints about her overwork situation and that she was having difficulty with her duties, she did not mention that there was any impact on her health or that she was truly having difficulty coping in the sense of that she felt vulnerable to injury. And the terminology the Court used was that her complaints were really of an industrial relations nature rather than a medical nature. And so in the absence of any signs to really put the employer on notice that her health may be affected and that there was a risk of injury, it was held that the employer could not have foreseen the risk of psychiatric injury to the plaintiff. The next case I'll speak about is Hardy and Micropool, a decision of Justice Jack Forrest of the Supreme Court that's a couple of years old now and that David ran. And this is another true overwork and onerous duties case. The plaintiff in this matter was a service technician employed for several years. And there was evidence that in these nights away from home, and there were more than 50 nights in the year prior to him ceasing work, the plaintiff and other co-workers would often consume large amounts of alcohol and smoke marijuana. And the plaintiff asserted that the employer had breached its duty of care by requiring him to work away from home for these lengthy periods. And he argued that these extended absences, in addition to being exposed to a drinking and drug culture of his fellow employees, led to a major breakdown and psychiatric injury that caused him to cease work. And it was the court's task to decide whether his psychiatric injury was reasonably foreseeable to the employer, and if it had been, what action should the reasonable employer have taken in response to it. Now again, echoing the High Court in Koehler, the court looked to the contract of employment in determining the scope of the duty. And the plaintiff had really pushed an argument that he was effectively forced to stay away from home and had requested that he have duties that didn't require him to stay away in regional Victoria, but that he'd been required to. And His Honour noted in relation to that argument that it was based on a significant misapprehension of the relationship between Micropool and Mr Hardy. His Honour noted that he was not forced to go away for long periods, and he commented, "This was not the Soviet Union under Stalin or his successors. Australia is not a command economy, and Mr Hardy, knowing the tasks he was to perform and knowing that he would be away frequently, entered voluntarily into the contract and received extra remuneration to compensate him for the time he had to spend away from home." And His Honour noted he could have resigned any time and sought a more suitable role if he'd wished. So again, we have this real emphasis on the freedom of the employer and employee to enter into a contract for whatever level of onerous duties that they consider appropriate, and the court's reluctant to look behind their freedom to contract to impose a very strict duty to employers to alter duties or to be too worried about how their employees are going in the duties they've agreed to perform. With regard to the claim by the plaintiff that the employer should have taken steps to control the behaviour of the co-workers in the drinking and drug taking after hours, His Honour confirmed that the employer's duty does not extend to regulating that kind of behaviour, and although there are types of cases where an employer's duty, of course, may extend beyond the very workplace itself, that duty cannot extend any further than where the conduct is in truth an integral part of the employment duties, and certainly not to the extent of an employer being able to dictate what its workers should or shouldn't do with their free time after hours. And His Honour noted by way of social commentary that drinking and smoking marijuana is part and parcel of working life in this country. In relation to foreseeability of the plaintiff's injury, having found that in general the employer's duty was not likely to be found to be breached as the plaintiff had freely entered into the agreement to perform the duties, the court also looked at the signs the plaintiff had given to the employer that to consider whether or not the risk of injury had been foreseeable. And it was important that, as in Koehler, the plaintiff hadn't made any complaints related to his health, although towards the end of his period of employment he was receiving treatment and was suffering ill effects of an injury. There was no correspondence from doctors and no complaint that he was really having health effects as a result of the duties. And the language of the court was that the complaints were more in the style of grizzling between fellow employees rather than actually giving notice of a potential vulnerability to psychiatric injury. And it was the court held that simply expressing a desire to stay home rather than be away, no matter how forthrightly you express that desire, does not put a reasonable employer on notice that you may be at risk of injury. So this injury was found not to have been reasonably foreseeable. So clearly, in considering this sort of factual circumstance in preparing a matter like this, we see the real importance of looking carefully at the contract of employment itself and really distilling out the terms in relation to what duties were agreed to and whether the duties performed were within the contemplation of what the parties had contracted. And also looking at precisely the nature of the signs the employee was displaying during the period that might be said to have put an employer on notice of risk of injury. Are they signs of true ill health effect? Are there uncharacteristic absences or any medical certificates? Or is it more in the nature of an industrial relations problem, being the Koehler language, or grizzling from Hardy? To come up to more or less the present now, Lana and George Weston Foods, a decision of the County Court from this year, which has gone on appeal, is another true overwork case. And of course, there will be people in the room who've been in these cases and run them, and it'd be great to hear from you at the end with any comments. In this matter, the plaintiff alleged psychiatric injury from very onerous duties as a logistics manager. He gave evidence that he had a huge volume of work and that the role he inherited was in a state of disarray, and that it was hugely onerous for him to try to cope with his role, and that he was not provided with support from his superiors despite repeated requests. And he gave evidence that he had reported to his senior managers that he felt as if he was drowning in his duties and was truly failing to cope. As is the case with all the matters that I'm speaking about today, there's commonly a large volume of competing lay witness evidence from the plaintiff and the employer, and in this case there was certainly contradictory evidence in relation to the nature of the duties and in relation to the complaints that were made. And on balance, the court, of course, had to enter into a weighing process and assess the credibility and reliability of all that evidence. And the court did not accept the plaintiff in this case as a reliable witness, and it looked at matters, at factors such as that it found the plaintiff was very litigation-focused, as revealed in medical reports and histories to doctors, and that he'd in fact found that he had exaggerated his work hours to doctors. And his evidence about his complaints to managers that he gave at the hearing was actually differed, or it was inconsistent with some of his answers to interrogatories. So as a result of those factors, and because the court was impressed with the reliability of the employer witnesses, being several senior managers who'd worked closely with the plaintiff, the court found that it preferred that evidence and found that there hadn't been those signs or complaints. It was also important that the plaintiff had been recruited. He'd started in the role in a contract position and then been engaged in a full-time role as logistics manager, and the court accepted that as part of his role, the role that he'd contracted to perform, he'd been recruited to deal with some of those inefficiencies and workplace problems that he said made his job almost impossible for him to deal with. That was in fact part of his role for him to be dealing with those inefficiencies. So this case was argued on a true breach of contract basis as well as in negligence, and the plaintiff argued that there were express terms of his contract that were oral terms arising from conversations with his senior manager at the time he was engaged, to the effect that he would have a second in charge employed to help him in his role, and that he would have support and inclusive working relationship with his superiors. And because the plaintiff's evidence was not preferred to the employer's evidence on this point as well as on other points, those contractual terms were found not to be made out, but the court spends significant time distilling out what the terms of the contract in fact were, and reading this case is a really good reminder to engage at the outset of preparing a matter or taking instructions in that process of considering if this is an overwork matter, exactly what do we say were the terms of the contract, what were the duties that were agreed to be performed, and can a court be satisfied that the duties to be performed that were contracted are this version and not a possible other version. So again, we see the aspect of Koehler coming out about the importance of the contracted duties, and this case was a really interesting, I think, attempt to argue a proper contractual point that there were concrete express terms that were breached that gave rise to injury. The last case I want to speak about, which is also a very recent one, is the matter of Brown and Morris Blackburn Cashman, a decision from a county court decision of Judge Carmody from May this year, which is also an appeal. The plaintiff in this matter was the head of the Family Law Department at Morris Blackburn Cashman, and alleged that a course of harassment and bullying from a fellow partner through emails and conversations during and after her maternity leave in 2003 had given rise to her psychiatric injury. And the plaintiff had complained of these behaviours to the managing partner, who'd taken certain steps, including talking to the parties and arranging an informal mediation, which hadn't resolved the matter. As with Lana and as with all these cases, there was a large amount of lay witness evidence at the hearing, and it was often contradictory. The plaintiff gave evidence, and the employer led evidence from the alleged harasser, the co-partner, from the managing partner who'd been dealing with that troubled relationship, as well as from other lawyers and support staff in the department at the time. And again, of course, the court had to engage in a weighing process of assessing what evidence was to be preferred and accepted. And as in Lana, in this matter, on balance, His Honour found that he was more impressed with the evidence of the defendant witnesses and found them reliable. And he found that the plaintiff, there was a difference between her perception of how the matters had transpired and the reality. And the court was assisted in making that assessment because much of the alleged harassment and behaviour was contained in emails. So the court really had that reference to assess whether the behaviour amounted to bullying or not. It wasn't simply reliant on competing oral evidence about those matters. And the court found that although the conversations and emails were certainly regrettable, being the language of the court, and that they clearly showed that both parties to this difficult working relationship were working under a huge amount of stress, that their behaviour couldn't reasonably be seen to humiliate, victimise or harass the plaintiff, and the plaintiff failed. Importantly, the court emphasised in this matter that in considering whether breach of duty has occurred by an employer in circumstances like this, the focus really has to be on considering the facts and what was known and what could have been known at the time the matters were transpiring and at the time the alleged breach occurred, and that it's important not to be distracted by litigious hindsight later after it's transpired that in fact certain events have given rise to psychiatric injury. And His Honour quoted Chief Justice Spiegelman in the case of Nationwide News and Naidu, noting that this reminding ourselves to consider matters not with litigious hindsight but from the point of view of the people involved at the time is particularly important in psychiatric injury cases, as in any organisation, situations creating stress will arise or may in fact be endemic. And the law of tort does not require every employer to have procedures to ensure that employees are protected from psychological distress. And so there's no breach of duty, notwithstanding that there may be a very stressful workplace, unless a situation is seen to arise which requires intervention on the test of reasonableness. So there's clear acknowledgement that stressful situations arise, and the employer's duty does not extend so far as to protect employees from stress or difficult interpersonal working relationships. The final aspect of Brown I want to mention, though there are many interesting aspects, is the level of scrutiny that the court subjected the expert psychiatric evidence to. The plaintiff led psychiatric evidence from several treating psychologists as well as some medico-legal experts, and her treating psychologist of 8 years, a psychologist of 35 years' experience, gave evidence supportive of the plaintiff's case. And she had been asked to consider some video surveillance footage which showed the plaintiff and give evidence about her perception of the plaintiff in that footage, in which the plaintiff looked cast down and depressed. And when answering questions about the plaintiff's behaviour, the expert witness became emotional, and the court commented that it found that over the long history of the treating relationship, the plaintiff and the psychologist had become very close, and that this diminished the expert's ability to maintain professional impartiality, and that she had therefore uncritically accepted much of the history that the plaintiff had given over the years, and that this significantly compromised her evidence. And there was also scrutiny and criticism of the subsequent treating psychologist whose methods were found not to provide a reliable basis for professional opinion, and that's a person whose methodology has come under scrutiny and comment in other matters as well. But clearly the evidence of the treating psychologist or other treating doctors in a matter like this is extremely important. And in general, if you're preparing a matter for the plaintiff, of course, a supportive report and opinion from a long-term treating psychologist who's reputable and experienced might be cause for some confidence, at least about that part of the case. And this is really an interesting reminder, I think, about the close scrutiny and the really rigorous application of the laws of expert evidence that courts will apply, and their willingness to engage in a real analytical process and look beyond the face value of reports to get to the basis and to assess the credibility of witnesses. So just to recap a few of the key points that jumped out at me while going back over these cases. First is that the importance of considering whether breach occurred from the point of view of the people involved at the time and not having judgment obscured by litigious hindsight. Secondly, it remains the case since Koehler that where there are no signs of actual risk of injury, where complaints are of an industrial relations nature only, the employer is still not likely to be liable in negligence. Thirdly, the contract of employment informs the content of the duty, and the terms of the contract and the duties that were agreed is an extremely important matter. Fourth, all these cases give rise to really complex factual disputes, and much turns on the credibility of the witnesses. And of course, we can use our interlocutory investigative steps, such as really targeted use of interrogatories, to try to understand the opposing case in as much detail as possible well ahead of trial. And finally, my final point about the credibility of expert psychiatric evidence and the real analysis and critique that courts are likely to subject that sort of evidence to. Thank you.